Good morning, everybody. My name is Michael Froehlich from Community Legal Services. I know I've met many of you in real life back when we were doing that, but it's so good to see everybody here. I have been excited about this session for months now, and so I'm really happy to have it to do it. In a moment, I'll introduce our guests. But let me just tell you a little bit about how this all came about. Community legal services, from time to time, people have come to us historically with tangled title issues, with deed issues, with issues regarding their heirs, with family homes, and we've kind of struggled with how to respond to it. There's about 20,000 homes in Philadelphia have what we sometimes call as tangled titles, which again we'll talk about in a second, and we didn't really know what to do. And then a couple of years ago, through the advocacy of folks like Judy Berkman, who I know is on the call, we were able to get some money to really focus on tangled title issues. And Dot Goldberger, who's the first person I'm going to introduce, who is a paralegal with us at Community Legal Services, came aboard just a little, gosh, I think a year ago. I think this is your year anniversary. And since then has been just doing tremendous work on this. And then this really amazing thing happened in Philadelphia. Tracey Gordon became our elected Register of Wills, and really has really changed things dramatically. Hey, let me ask you a question for those folks. Put in the chat box if you know the name of the Register of Wills in your county or any of the counties that you work on. I think most people don't, because it's kind of an, you'd be surprised to find out, Register Gordon, but I think most people don't. Well, I'm here to tell you that Tracey Gordon is the Register of Wills of Philadelphia, and she's here today with Ms. Sharon Wilson, who is a solicitor, and Terry Booker, who's the assistant solicitor. Let me tell you about how I first met Register Gordon. So last year, almost a year and a half ago, I was moderating a debate in West Philadelphia, where I live, at a church just down the street, and it was about the sheriff candidates and the commissioner candidates and everything. And of course we invited the Register of Wills candidates, not really expecting anybody was going to show up. And then Tracey Gordon shows up. Now, Register Gordon has been a lifelong advocate in Southwest Philly, a block captain for decades, been working on a whole bunch of issues from quality of life traffic issues to racial justice issues. And Tracey comes into the church where this debate was happening and starts talking about the role of the Register of Wills on intergenerational wealth, about saving family homes, about the role it has in helping people remain in neighborhoods when their neighborhoods start getting gentrified, and really casting the Register of Wills office as not just sort of a bureaucracy, a city government office, but as a real office that can be used to advance social justice, racial justice aims. And she's now been in the office 9 months or so. And in that time has really increased the outreach that the office, has created outreach, I think, in the office and going out to community groups. And so we're delighted to talk today about the role of the Register of Wills office and probate in general for our clients. As I mentioned in the session description, for community legal services, and I know for the Register's office as well, we see the work of helping families untangle tangled titles and preserve family homes as a racial justice issue. The median Black family in our country owns just 1/10 of the wealth of the median white family. And because the family home typically makes up about 2/3 of a family's wealth, one of the best ways that we can close this racial wealth gap is through building intergenerational wealth, preserving the family home. And so that is why, in my opinion, and I hope after today you'll you'll understand this as well. The work of legal services, the legal services should see this type of work as really a core part of the work that they do. All right, so that's my little introduction, or not so little introduction. With that, I think what I'd like to do is just turn it over to Registrar Gordon. And maybe I'll just like throw you a softball question, which is, can you start by just saying, like, what does the Register of Wills do in Pennsylvania?
Yes, good morning, everybody, and thank you, Michael Froehlich, for inviting me, and thank you to your staff. I met Kelly once, and I'm really excited to partner with you all. When I was campaigning to run for this office, I looked to you all as sort of a research firm for me to understand the dire consequences of living in a tangled title or living in a house that you think is heir property and you can't do any business with it because it's still in the deceased person's name. And so I've been in office, I took my oath in January, and I'm learning as I go along, which is the reason why I included and brought both of my attorneys, my solicitor, which is Attorney Sharon Wilson, who has decades of experience in estate law and wills and estates, and also Terry Booker, who I retained, who was working in the legal department, and I put her on as our assistant solicitor because I felt that I needed to bring strong people with me that understood the importance of financial literacy. And so one thing that we found out, and most people don't know, is you're correct. Most people don't know that the office exists until somebody dies, or until they want to get married, which is part of the Register of Wills. But I wanted the listening audience to understand some important things and facts about the Register of Wills office here in Philadelphia. First of all, we're a state office. We're not a city office, and we fall under the state agency. We fall under the First Judicial District of Pennsylvania. This office has been in existence since the 1600s. That's how important this office is to Philadelphia. It was here well before the Revolutionary War. And so a lot of people don't know that. We're pretty much self-funded. Last year, we brought in with our services close to $7 million, and our budget was close to $5 million. Last year, we sent to Harrisburg, or the state of Pennsylvania, in inheritance taxes, $80 million. Each year, we send $80 to $100 million. We are neck and neck, or we go 1 and 2 with Montgomery County. And so Philadelphia is very rich in history. We preserve archives that date back to the 1600s as well. Some of the things that we do, besides, of course, issue marriage licenses, and we retain those records as well. We validate wills, we collect inheritance and estate taxes for the state. We also probate estates. We assign executive privileges. We issue short certificates. We preserve all records, marriage records, that is estate records, wills. We preserve all of those. And also I am clerk of Orphans Court. So we oversee those records as well. Most people don't know that. And so when I decided to run for this office, mainly because I felt that it was too important of an office for people or the citizens not to know exactly what this office serves and why it exists. And obviously, that is a good reason, because we wouldn't have the large amount of tangled titles that we have. And roughly, they say that it's between 14 and 18,000, but we believe that is more. And we're trying to get the Pew charitable organization to do some research on it. And so 3 things that I ran on. I said, one of the things that I would do is make sure that I educate the citizens of Philadelphia about all the operations of the Register of Wills. And we've done that, and we're doing that strongly. I created, for the first time in the history of the Register of Wills, a full outreach department that includes access. We revised our website, and right now it's in 2 languages, Spanish and English, and we're working to get it into Mandarin. And then another thing that we've done is we created social media sites. And so we're on PHLROW Twitter, we're on Facebook, we are now on LinkedIn, and we have just begun going out virtually to legislators and holding what we call the Plan, Prepare, Protect webinar series. Plan your estate, prepare your heirs, and protect your assets. And for the first time in history, we did one of those webinars in 2 languages. We was with Representative Burgess, State Representative Burgess, Danilo Burgess, and he translated an entire seminar in Spanish. The ones that we've done so far, you can go on our Facebook page or on our Facebook pages, and you'll see them in its entirety for you all to review. The second thing that I said that what I wanted to do, and Terry will go more in detail about what we're doing, is I wanted to address the Tangled Title issue. And in my power, what I did was I have created a program to defer the fees, because I had talked to attorneys like Mike and Kelly and some other attorneys in community legal service, Christian legal services, including legislators that were saying that a large amount of their constituents that are in Tangled Titles, they cannot afford the fees. And because, you know, these fees are set by the legislator, I can't waive them. So we created a model that we can defer them. In other words, we are not going to come after any of the constituents that we defer the fees if they're living in a house and their families is living in a house. The only requirement is when you sell it, we will place a lien so we can retain our fees. And also, we want a requirement that if they do participate in the program, is that they make a will, because that's what we want to do, educate people, and we want to halt the Tangled Title crisis. And then the third thing I wanted to do was to diversify the office, and just not just a racially balanced, but sex, and give other people the opportunity to bring their talent to the office. And some other things that we did for the first time, we have an answering service, and we also have, within the first 60 days that I was in office, of course, COVID hit us, and it hit us really hard. And we, within 1 week, we were back up in operation, and we was holding virtual marriages through what was called the Quaker marriage. And a Quaker marriage is, you simply do not need an officiant to oversee your, or they don't have to officiate over your marriage, which helped them be able to get married virtually. And then we created virtual probate, because of course people were dying. And so we made sure that people, through their lawyer, was able to conduct business even in a crisis. We are also one of the only offices in the city of Philadelphia that is open by appointment only. And the reason why we created appointment only is because we do have to protect our workers as well as the constituents that come in our office. So we're one of the first, I believe, only office in the city hall that have outfitted all our desks and our sitting areas to be in COVID compliance, which includes plexiglass and the 6 feet distance. And we did that all within a couple months of the COVID crisis. And so another thing that I'm finding, and I'm finding this through the legislature, is because they have so many of their constituents that are entangled titles and didn't realize they were entangled titles until they either wanted to sell the property, which you can't because the deed is not in your name. They want to transfer or pass it down to their kids or their other relatives. They can't because the deed is not in their name. Homeowners insurance, to me, that is a liability everybody that has a home that lives, particularly in a row house, should be required to have homeowners insurance. But you can't get homeowners insurance if the deed is not in your name. And one of the major problems that I've seen, and that's when I learned about it, was we have a program called Basic System Repairs, which is government grants, whether it be local, state, or even federal grants that will assist you in the restoration of your property if you can't afford to, for instance, have electrical work done, or as a senior, you need to get your house outfitted so you can have what you call an escalated stair, but they can't do it because you need the petition of the owner or record of deed, but they're dead. Another thing that I don't think you all realize is my daughter, who recently traveled to Puerto Rico to do some philanthropic work to help them rebuild after the big hurricane, not the last one, but the one before that. She found out that you cannot even get FEMA. Now, FEMA is different from insurance. Insurance you pay for, and then you get your reimbursements if it's something catastrophic or something happened. But FEMA is governmental grants or governmental assistance that those people in Puerto Rico who rules actually blew off did not qualify for FEMA because the deed is not in their name. And this all has everything to do with financial literacy or lack thereof. And as a registered wills, I feel that it is my responsibility to, one, make sure everybody know what we do, go to the legislature and have them implement educational programs to educate our students. High school students should know everything about wills, estates, trusts. That should be incorporated in schools. A lot of them inherited. Some people, as a consequences, may be a minor and their parents die and they may be in line to inherit something. And I think they should understand that. And lastly, what I'm finding is that people are losing homes. And everybody on this call knows that the number one American dream item is to one day, of course you want to graduate and go to college and marry, but that one thing that you want to have is a home so you can have a safe, healthy place to live and raise your family. And because of this epidemic of tangled titles, families are losing their homes, have lost their homes, or are in line to lose their homes. And not only is this costly to the individual family, but it costs the citizens of Philadelphia, because look at all those abandoned lots and abandoned homes. I would guarantee that they were in tangled titles, and that's why they were sitting there in disarray, and we had to tear them down. And that all came through our from the fact that we weren't responsible enough as a government to educate our citizens on the importance of making wills, financial literacy. And so we created a program called the Probate Deferment Initiative. And it's launched this month. We haven't gotten our first client yet because we are in the process of making an announcement to see if we can get attorneys to come and assist organizations like VIP, Community Legal Service, because we're going to need a lot of attorneys, because some of these estates are, some of these clients are in very complicated estate challenges. And so that's the one thing. And then another thing, we had to make sure that our office and our staff was educated on the process of when someone comes in with a PDI or a probate deferred initiative, we know how to exactly deal with them and help them. And so this part of the program, I would like to turn over to Attorney Terry Booker, because I want her to really explain to you in detail what the Probate Deferment Initiative is and how, hopefully you all, if any of you all are attorneys, may want to volunteer 5 to 10 hours a week, 5 hours a week. We'll take any amount of hours to help us. And I'd like to thank you all. I want you all to visit our website. You can critique it. We're on Row Online at phila.gov. you can go and you can contact me. I'm at tracy.gordon@phila.gov if you have anything that you think that can contribute to assisting me in helping the citizens of Philadelphia become more financially literate. Thank you, Mike.
Thank you, Tracy. Terry, before you go, I want to post in the chat the Facebook page for the Register, because as Register Gordon mentioned, there's a lot of great material there, especially about like outreach that could benefit from our clients, and a lot of the videos that you've done with groups. Ms. Booker, could you maybe start because I know that there's some people on the call who may have just sort of a fuzzy idea about what tangled titles are. Could you maybe just sort of like say like what is a tangled title and like how does it get that way before you talk about the deferment program? Oh, can you unmute? How about
there I am.
Oh, sorry, I didn't know that I needed to actually do that. Sorry.
I apologize. This is Kelly. If I could just launch the first CLE poll, it's that time when I need to do it. So I'm going to do that now, and then Terry, please continue.
Okay. Yes, so thank you, Madam Register. The Probate Deferment Initiative, it's designed to help those people who can't afford to pay probate fees up front with or without a will. And as Madam Register stated, she wanted to crack down on the Tangled Title crisis that we're having here in Philadelphia. So a Tangled Title is simply is an issue with the legal ownership of the property, and it could be because of an imperfection on a deed. And that can be many things, even if something's spelled wrong, or simply having a decedent on the deed, and the deed of the house that you live in. So for the Probate Deferment Initiative, PDI for short, as long as you stay in the house, we're not looking to collect those fees that we have deferred. In some cases, it may be other assets in the estate, but as soon as and if you decide to sell the property, we will be expecting those fees as soon as you receive access to those funds. But if you're staying in the program, we also are offering, through the help and collaboration of the Recorder of Deeds, the Commissioner of Records, he has allowed for any of the people who are in the Probate Deferment Initiative, for those who are staying in the home, if they decide to, when they decide to change the deed over, which is the most important part of the untangling the title, those fees are also going to be waived. Those fees are going to be waived, not deferred, waived, because you might not have those funds as well. Excuse me. So we talked about probate, but what is probate? Probate is getting the legal authority to handle the business of an estate. So when someone dies, they may or may not have a will, but you need to get authority from the Register of Wills to go into the bank account, to change the deed, to do all of those things. So if there is a will, and after this conversation, as the Register suggested, you should have a will, the executor is going to go and bring the will to the Register of Wills. And excuse me, and once they bring the original will, they're going to also need the death certificate, original death certificate, and they're going to need their ID. Now those are two things that you need whether you have a will or not. You need your original death certificate and ID. So for those estates that have wills, it's suggested that you get a self-proven will. So you don't have to add additional paperwork that verifies that the signature is exactly whose it says it is. And that's what a self-proven does. Self-proven will does is used to acknowledge and verify under oath, like with a notary, the witnesses viewed the testator, which is the person who did the will, signed the will, and in their presence. So once you bring that will that is self-proven down to the Register of Wills office, you're going to, it's a petition for probate. That's what it's called. And you'll sit before a clerk and you'll, sign the affidavit to the petition, and you'll take an oath saying that you are going to handle the duties of being an executor to the best of your ability and rightful, as stated within the will. And then you have to pay the fee. So some people, this is why the probate deferment initiative is so important, because some people are not able, even if they have a will, are not able to pay those fees. If you do not have a will, the process is the same. You come down to the Register of Wills, but the difference is you have your original death certificate, but there's no will. So then there will all the intestate heirs, according to the Pennsylvania law, they've decided who's gonna serve for you. So according to intestate, in order, either the surviving spouse or then the issue of the decedent, which is the children, and it goes on and on after that. So not to get too technical. So once you, all those, and if there's a spouse and children, then there wouldn't be no need for renunciations or anything, because the spouse is the one to serve, just to give an example. But renunciations, I said, what is renunciations? Renunciations are forms that you sign either in front of the clerk or you have them notarized outside of the office in order to allow the person to do the work. You're not signing over any of your rights to the estate whatsoever. You are just allowing someone to do the work. And siblings, they'll all say, okay, you're the responsible one. You're gonna take care of the estate. So the problem that comes with that is that this is why you need a will, so you can decide who's the responsible one and who's going to take care of the affairs of your estate. So once you, as the register has mentioned, we started a virtual probate as well. And the process is the same. It's just through the mail. And if once we have all your paperwork, then you visit the website, and you can make an appointment. So even after if you find that, oh, I need to make an appointment, am I ready? You can go on our website at www.phila.gov/wills, and you can click on the questionnaire, and it will tell you if you are ready. Do you have the death certificate? Do you have your ID? Do you have the original will? And if you have all those things, then you can either call or send an email to probateappointments@phila.gov, or probate, PROBATE @APPT@phila.gov. So that's where you will go to make your appointments. And that we are, as Madam Register said, we are open for in-person and for virtual appointments. So with all of that being said, now when you have all your documentations, you have your ID, you have your death certificate, your will that you're going to create, and all of those documents come to the Register of Wills, and the register accepts your petition for probate. And then you will receive letters of testamentary or letters of administration. And when now we have installed in our office that if you come for an in-person appointment, you have to go immediately over to inheritance taxes to learn about what you need to do in order to file your inheritance taxes, because all probated estates must file inheritance taxes. And Sharon Wilson, our solicitor, is going to tell you all about that.
Terry, thank you so much. Sharon, before you begin, there was a question in the chat that I wanted to just bring up, which is that Karen Wheeler, who's works here at Community Legal Services. Hi, Karen. How are you? Asked a question like, what are the probate fees? Can you, for a person who may, have a family home that's worth, $100,000 or so and no other assets, do you know offhand like what the probate fee is for somebody?
Oh, I'm sorry. So typically the probate fees for if you own a home and you're probating a home, it's about $400, $400 to $500, something like that. If you don't have a home, you might have only a few assets. Baseline is about $200.
Great. Thank you so much.
You're welcome.
And in that case, it's per estate too. So, the Tangled Title, that's for one person. But if you are, if this house is in going back 2 and 3 generations. And one of the things I failed to even mention, I apologize, is we are also in a crisis of people understanding the importance of making wills, which is the reason why we're sitting in a whole bunch of tangled titles. And I'm being very aggressive with that education. And I don't know, you're talking about years and years and years and years of people not understanding it. And I know that, there's a racial disparity in it, but in my travels, rich people are not making wills either. Middle class people are not making wills. White, Black, Asian, they're not making wills. It's just not a conversation people want to have. It is not in it's not in curriculums. I believe it doesn't probably even come up probably until you're in law school. When I purchased my house close to 27 years ago, no one told me to think about it. I mean, and whenever I think wills, people always think synonymously old age. And wills should not be synonymous with old age. It should be synonymous with assets.
Yeah.
Right.
And you can have acquired assets at any age. And so that is something that I would like you all to help us do, to help this make it a topic of this discussion. Just like if you're going to purchase a house, I want to go to the Realtors Association and ask them, and I'm also going to ask council to put some sort of legislation that when people buy houses and those titles transfer, that it is some information in there that requires them to understand, hey, you might want to think about making a will. Now, I know we can't make them do it, but I do think that it needs to be incorporated in just all aspects of financial literacy, especially when it deals with title transfer. And so that is something that I am being very aggressive on. The consequences of not making wills is us sitting in these tangled titles. And those tangled titles is simply a title that you think you have some legal interest in, you think is yours because your mother left it to you or said she left it to you, and she didn't leave a will at all. And down there sitting there thinking, well, I don't have to do anything until a crisis come up and they figure, hey, I really don't really have any legal authority over this house because it's not in my name. And that's where the crisis is coming. And my solicitor, Sharon, will go further in detail that some of the reasons why they are not even thinking about beginning the process of coming out of that tangled title is they think that they're going to have to pay these exorbitant estate taxes. So they really think that they're getting away with estate taxes. Or I've heard people say, well, my bills, are, they're, what you call it, when a senior citizen has capped bills, so they don't want to change that dynamic because they figure their bills will go up. But they don't understand in the long run the consequence that happens just in case they die. And then you're talking about estate after estate. That's why we need some volunteer attorneys, because these cases are not just going to be cut and dry. My mom died and it's just me and my brother. These cases are going to be, oh, this was my great grandmother's house, who passed it down to her daughter, which was my grandmother, and then my mom just died, and now it's me. So you're talking all these different estates and different dynamics, because the grandmother could have had 5 kids who had 5 kids, and it just becomes really complicated for us to be able to do by just the client coming in. And then somebody did ask, is there going to be an income requirement? And absolutely. And what's the guideline? I forget, is it 150% of the guideline, Terry? Sharon, because I'll pass the mic to you now, Sharon.
Yeah, that's the average will be. Remember, initially, the pilot program starts out with us using legal agencies, and they will be the ones to apply financial restrictions on the clients that they serve. And we find that it averages around 150% of the poverty level. But of course, you'll have to talk to the individual agency to find out exactly what their economic restrictions are for the clients that they serve. Now, I'm also going to talk about inheritance tax today. But before I say that, I just want you to think, as I'm talking about this, of tangled titles as something that happens akin to when you put your sneakers on and you tie your laces really tight, maybe 2 times to make sure that they don't come off. And then when it's time to take your sneakers off, you got to go in and find each of those knots and unravel it. So the complication is not because it's calculus. The complication is about the labor it takes to unravel each one of those knots. Well, one of those knots that you have to take apart is inheritance tax. Inheritance tax is a tax that the state applies on a transfer as a result of death. So anytime you receive something as a result of somebody else's death, there's an inheritance tax. And the thing about it is you may, for example, receive your grandmother's house as a result of death, and then you do 2 things. 1, you don't change the deed, and 2, you don't pay the inheritance tax. But the inheritance tax doesn't go away. It just stays there. It lurks in the background. Think of it as like a quiet COVID, right? It lurks there, and it just gains interest every single month. And it's not a large tax to begin with, but when you let it lay, it accumulates and it gets larger and larger. And then when you're trying to take out one of those knots, instead of it being a small knot, you get to that knot that says inheritance tax that needs to be paid, and maybe it's substantial and your clients can't pay it. So what you need to do then is to find out what it is, calculate it. Maybe there are payment plans available for it, but just not ignore it. Now, why should your client pay inheritance tax? Because as the register mentioned, a lot of people think that, well, the state isn't not often very aggressive about collecting inheritance tax in the beginning. If you have a bank account, yeah, they'll go in and they'll take that money out. But otherwise, they're not really going after you. It may be an issue of resources, I don't know. But there have been times when they've been aggressive, and there have been times when they're not as aggressive. And right now, they don't seem to be quite as aggressive, but you can't rely on that. But you need to encourage your clients to pay their inheritance tax, even if nobody is knocking on the door asking for it, because 1, it will affect them later. It will certainly come, it becomes a lien on the property. So it becomes an issue if you try to remortgage your property, for example. Maybe you need a second mortgage because you want some repairs done. Or maybe you need a second mortgage because interest rates have gone down and now you want to take advantage of it and you can't. It becomes certainly a problem at the time of sale. You think you're going to get $50,000 for your house, and it turns out you're only going to get $15,000 because you left this inheritance tax bill there that's continued to run and run and run. And maybe at that price, you really can't afford to sell your house. So that's another reason that you want to, addition to the fact that we already talked about how it can complicate your whole tangled title issue. And also, we find as we try to collect the factors that lead to fraudulent conveyance. And if any of you have done any work around that, and by the way, it's really exciting that so many of you are interested in this topic, because for a long time, it felt like I was doing this all by myself when I was in private practice. But if any of you are interested in the fraudulent conveyances that are going on, when people actually go around and change deeds and steal people's houses. One of the things they're looking at is that they're looking to see what's dormant. You know, if inheritance taxes are laying around and haven't been paid, real estate taxes not being paid, that's one of the things they look at to see whether or not anybody is paying attention to this house. So another reason to pay your taxes is just to show potential, we used to call them fraudsters, but just to show potential thieves that somebody is looking at this house. This is not an appropriate target. Move on. We also find that non-payment of inheritance tax is one of the factors that we see when we're looking at houses or neighborhoods that are in line for gentrification. Now, gentrification can be a great thing in that it can target a neighborhood with a lot of services, but it can be a really harmful thing for the people who have been longtime residents of that neighborhood if the cost and the taxes around them go up. We can sort of spotlight neighborhoods and houses that may be target for gentrification the same way. Delinquent real estate taxes, and if they know that there's a death and there's been no payment of the inheritance tax. So when you don't pay your inheritance tax, you're exacerbating those figures that Michael talked about in the beginning. Now, you are unable, in a lot of cases, your clients are unable to take that property and transfer it to the next generation. They don't have the freedom to transfer it because it has a lien against it that they can't pay. So you are directly impacting the ability to not only create, but to maintain generational wealth down the line. And that's what adds to the figures that Michael talked about. If in every instance, your client has to start over from zero. So as if I don't have a house, you know, and I have to get the money to get the house, then I got to get a down payment, that all of those things are exacerbated by not being able to access the real property that's in my family because it was given to me. Oh, I didn't change the deed and I didn't pay the inheritance tax. And now, although I have it, I can't make use of it the way that I should. And again, that just contributes to that disparity. So that's inheritance tax in a nutshell.
Sharon, can I ask a quick question?
Pay a tax. Yes.
That's also, quick question. I know you've had a lot of experience in this. You know, a lot of times our clients come to us and say, well, you know, maybe in order to avoid the inheritance taxes or in order to probate, I'll just give away half of the house to my child now by adding my child to the deed now. What do you say when people, or maybe, I don't know if you can give advice as your current capacity as solicitor, but back when you were in private practice, what would you say to clients when they came to you and said that they wanted to do that?
If the house that they're giving away is in their name, because often clients say, what I'll do is give my grandmother's house to my kids. Remember, we first have to transfer the house to the client. That's a transfer by virtue of death, so that's inheritance tax. And because it becomes a lien against the property, if you transfer it without satisfying the lien, you're giving your kids the gift of debt. Congratulations. So we don't want to do that. But if the property is in your name, you can certainly transfer it, but you need to understand that to the extent that they will receive the balance of that transfer at your death, they'll be subject to tax for the amount of that balance. So if you transfer away 50% and you retain 50%, my kids will get that 50% when I die, they will have to pay transfer on that remaining balance.
Yeah, great. Yeah, that is an issue that we encounter a lot, legal services. We also, in addition to sort of telling people about exactly what you just said, we often warn people about, you know, if you add, quote, add your child to your deed now, you may be on good terms with your child now, but 3 years from now, when your daughter gets mad at you and tries to kick you out of her house.
That's right.
Yeah.
And you know, the other thing, Michael, to remember about that, and you can all, you know, talk to your clients about this. When you add someone to your deed, you're adding every bit of their credit and bad credit and whatever that luggage is, they drag it right with them to that deed. And when you go to then do something with your deed, you say, well, no, that doesn't come up until after I die. But the people who are lending you money or making those decisions say, no, we look at those things right now. So be mindful. If you know your child or your sister or whoever doesn't really have a good credit record, think about that when you decide, I want to put them on my deed.
Yep, I 100% agree. You know, the other issue, I know there's a lot of people on this call who do some work with Medicaid, nursing home recovery, estate recovery, things like that, but also just, you know, always need to be careful about the transfer of asset penalty. So you're a senior and you're giving away half of your house, your home to your child, that's giving away an asset that may affect your eligibility for Medicaid as well, or nursing home eligibility.
I noticed that Judy Berkman wrote that she usually advises that that kind of planning be done by will. But you know, sometimes there's a good reason to do it by deed. That you want to get it done now during your lifetime, sometimes to make sure that it happens. So there are some times when you say the deed may really be the best mechanism, but like her, I try to do it by will whenever possible.
Yeah.
And you're right, that planning will allow us to, for example, to get that property out of a person's name so that they don't have to worry about it in terms of Medicaid planning and the look back rules.
Yeah. Well, great. So I thank you so much to Registrar Gordon and Ms. Booker and Ms. Wilson. I'd like to turn it over to Dot for a moment. As I mentioned at the top, Dot has been just doing tremendous amount of work over the last year since she came aboard with CLS, working on tangled titles and helping folks resolve these issues. Ms. Wilson, I love your analogy about untying a shoelace. I'm going to be using that as well.
Yeah, me too.
Yeah, Dot, can you talk a little bit about the work that you do and lessons that you've learned that could be applicable to, that could be helpful for folks on the call? And I know you want to share your screen. Do you have the ability to do that, or do I need to give it to you?
Yes.
Terrific.
I'm just gonna full screen it if I can remember how to do that. Should be loading. So my name is Dot Goldberger. I'm a paralegal at Community Legal Services. I was hired almost a year ago to help CLS on their Tangled Title initiative. I was hired with funding from the Tangled Title Project, which is a project that works in collaboration with Community Legal Services, Philadelphia Legal Assistance, and Philadelphia VIP. I don't know why my PowerPoint is doing a little spinny thing. There we go. Can you see the screen?
We can. Yep.
Okay, great. So I just wanted to show a couple of things while I talk. So basically, I have been helping people untangle their titles. They come to us and they say, I've been living in my family's home, and basically the number one reason why people come to us is because they want basic systems repair program. Their house is not in good shape and they really want to help. They really need help with weatherization. They need help with fixing the steps so that it's safer for them to walk into their house. They need a new roof because it rains every time that it rains inside every time it rains outside. That's really what they're looking for. Also, sometimes people want closure. They need help dealing with this because their mom or their grandma passed away a long time ago, and they're like, I know I should have done this before, but I couldn't do it. And also they're like, I know that I need to do this, but I tried to do it myself and I just couldn't, and I need help. So that's why people come to us. They also know that Community Legal Services has access to various funding sources that can help them achieve these things. In the chat, somebody mentioned something about the Tangled Title Fund. That is an incredible thing that the City of Philadelphia has funded, which can award up to $4,000. It's administered through Philadelphia VIP, and it awards up to $4,000 to people who are seeking to resolve their tangled titles. But you need to obviously apply for it. Attorneys need to help you apply for it, and make sure you're doing everything correctly and everything like that. So that is a way that before the probate fee deferment initiative started, that we were really helping people pay those probate fees they couldn't afford. I think we'll probably still be using the Tangled Title Fund for the probate fees because as the Register of Wills office pointed out, like that is a great source of income for Pennsylvania. And if we have those funds, we should use them. And also, you know, it's a way to take care of them so that it's not a lien for people to deal with later. So I just wanted to point that out in terms of the Probate Deferment Initiative and the Tangled Title Fund. We're still going to be using the Tangled Title Fund. It's just for people who maybe the Tangled Title Fund may not work with. That's where I would use the Probate Deferment Initiative. It looks like Sharon maybe had something to say about that.
I was just going to say the Tangled Title Fund also pays inheritance taxes.
Yes,
so it
exactly.
may be that you get your probate fees deferred, but you can still use the Tangled Title Fund to pay the inheritance tax.
Right, exactly, right. If your inheritance taxes are so large that that extra $300, $400 from the probate fees would actually be way better to pay off the inheritance taxes in full, maybe that's a better way to deal with it. So yeah, I just, you know, shout out to Philly VIP. I don't know if there's any of them on this call, but I love them. So I just wanted to go through, are you seeing the full screen or are you seeing the side slides as well?
We're seeing, yeah, but it's fine. It's fine.
Okay. So you already talked about what is the Tangled Title, but I just also wanted to point out that Philadelphia's website actually has a really great breakdown, and it's I think it's on the Register of Wills website of what a Tangled Title is, and then why does it matter. And this is just like a really excellent breakdown from them that I use all the time of when I need to convince people that they should deal with this now as opposed to later. So as they said, mortgage, loans, payment programs, basic systems repair program, homeowners insurance, you want to plan for the future, you want to sell your home, etc. So how can legal services help protect family homes? Michael already talked about that at the beginning a little bit and Madam Registrar also talked about it in terms of this is a really great way for preserving intergenerational family wealth. Legal services programs can also get access to funds that people ordinarily wouldn't have. They can also help demystify and simplify the process, which, you know, it's not complicated, and there's a lot of steps. So really people can get so overwhelmed with the amount of steps. And so it's really helpful to have somebody on their side to kind of take it step by step with them and explain, like, first we do this, then we do that. Or say, like, let's just focus on step one right now. So it's really helpful to have somebody advocate for them, work with them on their side, and not, you know, have them be so overwhelmed that they're like, you know what, not my problem, I'll leave it for my daughter to deal with, which is something that I've heard before. And I'm like, oh, do you want to do that? I don't know. I just want to say, I think that it's really important to think about, like, for legal service, I don't know exactly who's on this call, but I'm thinking that it's attorneys and paralegals across the state who are interested in doing this kind of work. I think the really important first step for this work is to figure out why. Why did they come into the office? What do they want? And is it possible? Do they want sole ownership? Do they want record ownership, even partial, so they're eligible for home repair programs? Do they want to settle the estate because they know that it's hanging over their head, because they know that there's inheritance taxes, et cetera, that, like, they want to take care of so that other people don't have to take care of it? Is there an estate recovery claim that needs to be dealt with? And that is something that comes from the Department of Human Services. If somebody has received home or community-based services from Medicaid, or nursing home services, then Medicaid tries to recoup some of that costs, and they can do that via the estate, which generally means that they will try and that like they can try and do that from the estate assets, like the house. And so if there's a claim on the house, but then there's somebody living there, that's something you need to deal with, right? So ask them, I mean, really the first step is what's their aim here, and is it possible? The way to evaluate of if it's possible is you want to figure out like a lot of preliminary information. So number one, is there a will? I would say 2 or 3 of my cases so far in the past year have had a will. Most people do not. So it's complicated. If there's no will, you have to draw up a family tree and determine heirs. This site right here is Pennsylvania intestacy laws. The Register of Wills office already mentioned it. I just wanted to bring up the site right there for you so you can look it up. You want to ask them if the decedent received home or community-based services. I also want to say I'm talking about cases mostly where the title owner is deceased. That's not always the case with Tangled Titles, but since we're talking to the Register of Wills office, like in context of the Register of Wills, I'm mostly talking about deceased homeowners. So you want to ask them about Medicaid and DHS to identify potential Medicaid estate recovery issues. And you want to ask about real estate taxes, mortgages, water, gas liens, electric bills, state of the house, because you also need to figure out, you know, do you want to deal with this? And if so, how? Because if there's a lot of liens on the house, you want to figure out what exactly to do about those liens in terms of obtaining ownership, because obtaining ownership, like Sharon said, maybe somebody gave you the gift of debt. So you need to figure out how to address that. So here's just like a quick chart from Philadelphia about intestate descent. I cropped it because it goes much longer than this. There's many different levels, but it gets pretty complicated beyond spouse, issue, and, you know, issue of issue and stuff like that. So it is, and this is also exactly why it's really helpful for legal service organizations to get involved in this work, is because a lot of times people think, oh, this was my mom's house, and you know, my mom had 4 kids, but 2 of them died already. And so now the house is just me and my sisters, and it doesn't have to deal with anybody else. But that's actually not what the law says. What the law says is, did those 2, like your 2 deceased siblings, when did they die? Did they die before or after your mom died? Were they married at the time of their death? Did they have kids? Are their kids alive? Because that interest does not necessarily just evaporate, which I think is a really common misconception and is a really hard thing to convince people of otherwise. But it is, that's a really helpful role that legal services can provide, is explaining, like, this is actually what the law says. And so this is how we have to deal with it. To evaluate this, again, you know, you want to get the deed, you want to take a look at what the deed says. Philadelphia, I know this is across the state, but Philadelphia has their deeds online since 1976. Before that, from like 1955 to 76, you go to City Hall to get those deeds. Before that, you got to go to City Archives. Usually, Terry mentioned that she recognized my face. It's because when we were in person, I would be at the Register of Wills office once a week, pretty much, and I would also go to City Records in 154 in City Hall to get copies of deeds all the time too. You want to get a copy of the deed, because they might say it's my grandmother's house, But is it actually your grandmother's house? Did your grandmother and your grandfather own it as tenants by the entireties? And then who died first? So maybe it's actually your grandfather's house and you need to probate your grandfather's estate instead of your grandmother's estate. So see what the deed says. If there's a will, get a copy of that will. If they don't have the original, there's methods to deal with that. So you want to see if a probate has already been raised. Sometimes a probate's already been raised. So go to the Register of Wills office and ask about that. To raise a probate case, like the Register of Wills office said, you need an original death certificate. And then you're also going to need a list of their heirs and their contact information, because you might need their renunciations. And you're also going to need that for other estate paperwork as well. There's other forms of tangled title cases, and I just wanted to mention them, even though I'm not going to go into them. So there's adverse possession and there's rent to own. So adverse possession is maybe you've been living in the house for over 10 years. That's a law that changed recently. It used to be 21 years. And 21 years is also still a great level, but you want to get proof of residency going back, because going back for a period of time, because if you can show that you've been there for a long period of time consistently and notoriously, and I think there's a couple of other words that are really important, then that's one way to say, like, no, I actually have been acting as the owner of this house, and you should grant, and you can petition the court to say, I'm actually the owner of this house and I've proven it over these years in this way. If there's a rent to own case, this is also something that comes up where, there's a lease agreement saying that I'm going to, after paying this amount of money for this amount of months, then the house becomes yours. But then that agreement, what happens if the person you had that agreement with died? That's also really complicated. Or what if that person who you had the agreement with suddenly changes their mind and they're like, actually, just kidding. So those are other tangled title things. So this was already covered by the Register of Wills, but I just wanted to, I didn't know exactly what was going to be explained and not, so I just made some slides anyway. So probate is, the procedure by which a will is proved to be valid or invalid. If they didn't have a will, the estate may still need to be probated if they had assets. You can do it yourself, but it's easier to get an attorney to help you. There's a lot of steps, and it can be really overwhelming for clients, as I said, especially if the more time has passed since a homeowner died and there's more heirs that are involved. We've been talking about grandparents' houses. So that's, that's 2 or 3 generations that are involved in that process now. And if each of those generations had children who had 5 kids or 3 kids, or even just 1 kid, and there's, that's a lot of people to deal with. So the one thing that I've been able to do, which has helped my clients, is I have access to kind of spooky lookup systems like Westlaw, a thing called People Map, where I found somebody's long lost, their mother's long lost estranged husband who nobody had been in contact with after 55 years. So that's something that they hadn't been able to track down, but they needed to be able to raise the estate. So that's something that legal services, again, can bring their resources and assets to the table to help solve these cases. These are the main things, but not the only things that the administrator is responsible of dealing with, but these are the main things that I talk to my clients about. The main thing that people are concerned with, to be honest, is the deed transfer, but that's not the only thing. And that is, it's really important to explain to your potential clients that there are other things that you need to deal with. There's a lot of paperwork with the Register, well, not a lot of paperwork, but there's paperwork with the Register of Wills office. You got to deal with potential estate recovery claims, and you got to deal with inheritance taxes. So how do you avoid a tangled title? How should your client avoid a tangled title, or you? Because this affects all of us. If you own a home, you also should consider this. I do this work. I've been doing this work for about a year now, right? And for that entire year, I have been bugging my parents that they need to update their will because they own a home and they haven't updated their will since before I was born. So, time to do it, everybody. So write a will, plan your estate, discuss with your family what your intentions are. And this is advice for you to give yourself, but I also framed it as a way for you, advice that you specifically give your clients as well. So discuss with your family what your intentions are, what your wishes are, and where you're going to put your will, because they also need to know where the will is so that they can deal with it. It's also good to talk to your family about this ahead of time so there's no surprises, which can lead to family drama and disagreements. There's a lot of family drama that happens in probate cases. People feeling betrayed, people feeling upset, people feeling left out, people feeling confused. So it's also a way to take care of your family ahead of time to help mediate those things. And I understand that, like, it's easier to say, like, well, that's for them to deal with. I'm going to be gone, so whatever. But I think that it's nice to think about taking care of your family ahead of time. But that's just me. So a will is always the clearest way to plan your estate. It says who will get your house and your other property when you pass away. It lets you choose who's going to be responsible for your estate. So dealing with any debts when you die and giving your property to the people you want it to go to. So, you know, pick your favorite, most responsible child. Just kidding, not your favorite, but do pick a responsible child. Or somebody. If none of your children are responsible, maybe you're, you know, responsible lawyer, maybe you're responsible next door neighbor, somebody who you trust. Now is a great time to plan. That's important for you to plan, for your clients to plan. I am obsessed with your idea, Madam Registrar, and that's an idea that my supervisor and I have talked about before, of with every deed that gets recorded at the Department of Records, there should be a handout that comes with it about how to plan your estate, like what you should do now. Like, hey, congratulations, now you have a house. Get a will. And like maybe a list of referrals to the Legal Referral and Information Service or to legal aid programs that provide estate planning assistance. Like, I think that is a lovely idea. And I've talked about it before that, like, that's what you should do. Everybody who owns a house should have a will. It can be really difficult to think about and to talk about. I know that, you know, the registrar also talked about this. There's superstitions attached to it. Like you're asking for death if you think about it. But I'm not going to tell you that there's, you know, you have your own ideas and beliefs about superstitions. All I'm going to say is it's a great way to take care of your family. It's a really great way to take care of your family. And especially if you have kids, I mean, if you have minor kids, you also want to consider that as well. So I just want to bring up, as I said, there's many steps in this kind of work, and that with many steps come many problems. So frequent problems are missing documents. People say that there's a will, but where is it? Or people say that there's a deed, but they don't have a copy of their deed. People say that there's birth certificates or death certificates that say that you're related to this person, but where is it? So getting those documents can be really important in helping your client resolve their tangled titles. Also is unfindable heirs. As I mentioned, a lot of issues come up when there's multiple generations going on, and you know, you have lost track with your sister's kids because your sister passed away. So where are they now? Maybe legal services can help you find them. you do need your client to participate in this because you do need to know at least a little bit of information to find them. But maybe working together, you and your client together can find the heirs when in the past they have not. This is a complicated thing to talk to your client about. Sometimes they don't want to find them, but sometimes that's what you have to do to be able to get the house. So you have to talk to your client about the pros and cons of this. Do you want your house? Do you want to fix up your house? Well, then we need to take the risk to talk to find your heirs. Sometimes I take maybe more of a role in it than other legal aid workers would, which is I talk to the families more than maybe other people would, and try to soften the blow of reaching out of nowhere to be like, hey, do you want to talk about an estate? So yeah, I'll talk to their family members to kind of start that process. Or I talk to my client about like, is it better if I reach out to them first, or is it better if you reach out to them first? It depends on different families and different family dynamics. Frequent problems, I also put on here unaffordable probate fees. That's less of a problem with our wonderful current register. It is way less of a problem now than it used to be a year ago. However, it's also important to consider that like this is a new program and people are still learning, are like need to hear about it first. So it's still something that legal aid can help with, is talking to them and spreading the word about this. Also, this is something that our register has, our Philadelphia register has. If you're in another county, maybe you want to bring this to your county. Maybe you want to say, hey, Montgomery County Register of Wills, what do you think about this? Philadelphia's doing it. You also want to talk about whether the house is worth it, or like money-wise, concerning estate recovery issues. You also want to talk to your client about priorities. Sometimes it's not a priority for them because it's like, well, I'm living in the house, nobody's bothering me, why do I have to deal with this now? You got to talk through those issues with your client for all the reasons we stated before about why tangled titles are important to deal with sooner rather than later. I'm currently helping, Michael and I currently have a case where we need to raise the estate of somebody who died in 1974. So it's not a new problem. It's something we need to deal with, and you know, people across generations are dealing with it. So I hope you are all interested and excited about this kind of work and want to start your own tangled title programs in your own legal aid organizations, or support the programs that already exist and refer them to the legal aid, and refer clients to legal aid organizations that do exist.
Great, thank you,
Michael?
Dot. Thank you. I want to provide folks an opportunity to ask questions. One thing we haven't mentioned today is that often we're dealing with probate issues in the context of mortgage foreclosure. So a very common situation is where somebody buys a house, takes out a mortgage, or takes out a home equity line of credit on their home. They die, their children want to save the family home. And so, but in order to qualify for an affordable loan modification for the mortgage, need to assume the mortgage. And in order to assume the mortgage, need to raise the loved one's estate, raise the borrower's estate in order to transfer the deed to their names. Does anyone have any questions for Register Gordon or Ms. Booker or Ms. Wilson, Dot, me? If so, you can either put them in the chat or just unmute yourself and ask.
Mike, I did want to add something, and that was an excellent presentation. That I want to make sure that it is included in my website, so I'm having somebody check that out because that's perfect. It's simple and it's understandable. People keep thinking that we are the Department of Deeds.
Right.
And I think that should be included in this slide. And I'm definitely going to include it on my web pages because we are getting a whole bunch of calls and inboxes asking us, you know, are we open? I need a deed. And for some reason, they link the Register of Wills with the Record of Deeds. And so we are two different entities. They have two different leaders, and we don't have anything to do with that office. Another thing that Terry didn't mention to you all was we have an agreement with the Department of Deeds, and they are going to waive the fee for anybody that comes through the Probate Deferment Initiative Program. So we have agreement with, and we have it in writing. And so that's another perk, and that's another cost savings to the program. And I forget his name, but Terry, correct me if I'm wrong, they did put that in writing, correct?
Oh, wait, Terry,
you're
can
muted.
you unmute? Wait, hold on, I think I can do it. Wait, hold.
She's muted, but yes, it is.
There
Oh, there you go.
There you go.
Yes, yes, it is in writing. Yes, we have a mutual agreement of understanding.
Yeah, I'd actually be curious. To Registrar Gordon and others, you know, a lot of folks who are on the call this morning are in counties throughout Pennsylvania who may not have relationships with their Register of Wills office. Do you guys have any recommendations for people who may be working in other counties as to how to establish, you know, the relationship with their Register of Wills, how to sort of like get their register to meet with them to talk about some of these issues?
Well, I had the opportunity of meeting as a freshman is the Register of Wills Association. I'll get you the information. And they were all involved. They were looking at Philadelphia and saying, thank you, you all never came. Mm-hmm. So it is a Register of Wills Association that is extremely active. I mean, they gave me a binder this big for best practices.
Yeah.
So I simply would just look and see if they have a website and call them. But it is an association, and I'm not going to say all 67 counties were active, but I believe it was like 55 of them there. And they were actually shocked that I was there. But they had heard that I had won, and they were all anticipating to meet me. And so, yes, I would encourage you all to definitely just call them or look on their website, because from what it appears from when I went to that workshop, all others have been canceled because of COVID. They pretty much have a very active Register of Wills Association in the state of Pennsylvania.
Great.
And then some counties don't have Register of Wills, like they voted the Register of Wills out. I don't know the dynamic of it, but yes, it depends. In different counties do different things. Like we're considered a first-class city because the amount of taxes that we send, estate taxes. So some of them merge offices, and they call it. They don't call it the Register of Wills. So yes, I think you all should just give them a call. It seemed like many of them were active. So.
Great. I see that Kelly Yeckley has unmuted herself, which probably means that you want to do the next poll. Is that...
Yes, if I could just launch it. Attorneys on the call, please respond for CLE credit. And Michael, I can now click a button so that people can unmute themselves to ask questions if that's what you'd like.
Yes, please.
Okay.
Great.
Okay, that's been done.
Great, thanks. Does anyone have any questions that they are curious about? Or does anyone have any stories about sort of, is anyone working with their register or is doing this type of Tangled Title work in other counties in Pennsylvania? Do you want to relay your experiences?
Michael, this is Dan Haller from Pittsburgh.
Hi, Dan, how are you?
Good. Michael, we're using the probate code 20, section 3546.
Yes.
And you're not. Tell me what you think are the cons of using that approach, because we haven't gotten into the business of trying to probate wills,
Right.
because of the complications and the costs involved.
Sure. So you've asked sort of what a probate 201 type question, so a bit of an expert question. So I'm going to do my best to just give a gloss for the many people on the call who may not have a serious foundation or grounding in this work. But as several people have talked about so far, one way to resolve tangled titles where the record owner of a home is deceased and through the rules of intestacy, the actual equitable owners may be numerous, is to track them all down and to get them all to agree to sign over their very tiny, 1/32 interest in the deed to our client. It's laborious, but it's also sort of straightforward if the heirs can all be identified. Another possibility is what Dan just mentioned, is to file a 3546 petition with Orphans Court. A 3546 petition, which is named after the section of the Probate and States Code, is asking a judge, showing a judge, these are all the efforts I went through to try to identify all of the heirs. However, I just can't find them, or they're not participating, and you're asking a judge to issue an order putting the record owner of the property in your client's name. And in some circumstances, a 3546 petition can actually terminate the intestate interests of the heirs in favor of your clients. And I know, Dan, and I've talked with your colleague Tom as well at Allegheny County, that you guys have used this quite frequently. Here in Philadelphia, we have not, for various reasons that we don't have time to go into right now. But generally speaking, we have found more success actually tracking down all the heirs and getting them to transfer interest in the property.
But that doesn't mean we're not going to. We have a couple of cases where we're planning a 3546 because I did track down the heirs and they are uncooperative, to put it lightly. So we are going to try 3546 and see where that gets us. So there are options when probate is not, when you can't do probate because you can't get the renunciations.
Yeah. Maybe at the next planned conference, we'll do a session on 3546 versus probate, pros and cons, to get more deeper into this issue. Thanks for the question.
With the west side of the state and the east side of the state battling it out.
Any other questions? I know we're nearing a time. Maybe I have time for one more if anyone wants to unmute themselves. Oh, great. Well, then with that,
Can I just ask,
Dot, please. Yeah.
Can I just ask Terry to hold up her mug for everybody? That's the Register of Wills. I just love it.
So I wanted to close also with this is just in my little experience of sitting through citation hearings. If anything, I think that you should appeal to your loved ones, your clients. The amount of bickering and fighting that I have to actually hear in some of these hearings is if the deceased person realize that amount of pressure that they will place on their loved ones, because sometimes people just don't want to make decisions because they don't want to choose between family members, or they just don't want to, they just don't want to make that decision. And I've heard people say, well, I'll be dead, I don't have to worry about it. And in that case, yes, that's, probably true, because I've never been dead, so I don't know what you have to worry about. But what I do know is the effects that you leave when you do not handle your business. And I've seen very, very, very ugly feuds between families that, I think, people should understand that when they are resisting making this will. And another thing that I had chance to be able to hear is Medicaid or the Department of Welfare do come sometimes to ask to be, executors to collect their money on that house, and they don't want the house, they just want the money. So some relatives, are living in these houses and don't realize that, they have rights to retain their money back. And they will come if it's a substantial amount of money, and they normally offer the estate or the heirs to buy them out, or they'll just want to put it up for market. So these are some of the things that that for some reason, and I don't think we'll ever know the reason why it didn't become a habit to make a will. Because I'm sure back in the 1600s, that was a habit because, they were new landowners and they just wanted to protect their land. And now we're in, 2020, modern day society, or modern America, and people are not even thinking about that, or there is just, it just should be something automatic. And so I'm hoping in my tenure that we can collectively work on changing that mindset here in Philadelphia, at least. Thank you all for
in Philadelphia. Thank you. And Philadelphia and the entire Commonwealth of Pennsylvania. Let's set our goals even higher. Well, with that, Register Gordon, thank you so very much. Terry Booker, Sharon Wilson, Doc Goldberger. This has been a really fun conversation. I want to, everybody on the session knows how to get in touch with me. If you don't, I'm going to drop my email in the chat. Happy to answer any follow-up questions that come out after this session, or direct you in whatever direction you'd like to go. And with that, let's close out today. Hope everybody has a great Wednesday, and we'll talk again soon. Take care now.
Nice seeing everyone.
All right, bye-bye.
Thank you.